was delighted to be asked by the Federalist Society to join you all tonight, and I want to congratulate the Society for this symposium on unenumerated constitutional rights. It's your latest contribution to the current great debate on the meaning of the American Constitution. Never mind the outcome, I'm just relieved that the debate is occurring at all. It hasn't been so long since the Constitution was discussed entirely in terms of cases. And I remember that in earlier editions of the Gunther textbook, you don't even see the text of the Constitution until you get to Appendix B. Although when the Federalists pointed this out to Professor Gunther, he changed it to Appendix A. Well, major credit, I believe, is due the Federalist Society for sponsoring the symposia, the lectures, the articles, the monographs, which have really thrust forward the text of the Constitution as the central fact of American law, rather than its former status as a mere historical starting place for several generations of judges to think through for themselves how America should be governed. In the course of this debate, some of the speakers sponsored by the Federalist Society have uttered propositions which, while uncontroversial to the generation of the founders, have resounded like fighting words in the ears of Warren Court legatees. You will recall the most prominent truisms among them. The Constitution is a written document whose words were debated at length and carefully chosen, and therefore the founders' handiwork may be presumed to convey an identifiable meaning. The Constitution contains the means of its own amendment in Article 5, and so we may conclude that the original meaning of its provisions control until amended according to the Article 5 process and may not be changed through extra-constitutional infusions that some would give it. The Constitution itself, by its own terms, is the supreme law of the land, not the body of constitutional decisions which have grown up around it. The courts are bound by the written commands of the Constitution, no less than the executive, no less than the Congress. And the role of a judge is to fashion a rule of decision based on the case or controversy before him, and the rule of decision must interpret and apply a law. Well, these assertions about American law have found hospitality at the hearth of the Federalist Society at a time when legal academic establishment had barred its doors. And thereby, I really believe that these young Federalists, and they are still mostly in their 20s, have performed an inestimable service to their country and to the cause of ordered liberty. They think of themselves as a new generation of young Turks, and I suppose they are new in the sense of a particular set of people at a particular time. But they ask questions as old as civilization. Who should govern? By what authority? Through what means? And to what purpose? The task the Federalists have taken upon themselves is to pose these immemorial questions in the lexicon of our time in history. For as Whittaker Chambers reminds us, each age finds its own language for an eternal meaning. And in our age, the immutable questions of governance must be posed very largely in the language of the American Constitution, the great prop of the free world. And so the Federalists have learned that language, and they have posed their questions, and they have turned to the wisest among us for answers, and in so doing, they have lit a lamp to light our way. 50 years from now, when the United States celebrates the first quarter millennium of the Constitution, a new generation of lovers of the law might hearken back to the Federalist Society and the great debate about constitutional fidelity that occurred in the 1980s. And they may be able to say that it was a turning point in the course of American law. Well, who knows? But the Society can be justly proud of the effort it has already made at a critical time on behalf of those blessings of liberty that our Constitution secures. The central figure in the debate that I have described is our speaker tonight. When Judge Bork first started teaching and writing about constitutional law in the 1960s, there was no such thing as an interpretive school of thought. Political opponents of the Warren Court had called for judicial restraint and deference to the majoritarian branches, but were unable to offer any positive theory of the proper role of the courts in our system of government. In the academy, constitutional law professors were enamored of the Bickel and Harlan analogy between the evolutionary approach of the common law and our so-called evolving living constitution. American constitutional theory had become mesmerized by the example of Britain's unwritten constitution, with little attention given to the quite different set of problems posed for interpreting our own written fundamental law. Into this theoretical breach stepped then Professor Bork. In his 1971 Indiana Law Journal article, and in numerous subsequent articles and speeches, Judge Bork emphasized again and again that constitutional decisions by the courts are only legitimate to the extent that they are based on the words of the Constitution itself, as those words were originally understood, and as their meaning is illuminated by the structure of the document itself. Judge Bork rejected emanations, penumbras, and all sorts of conveniently alleged legal traditions of English-speaking peoples everywhere. He rejected them as ruses used by judges to do whatever they really want to do. As Judge Bork later put it, the truth is that the judge who looks outside the Constitution always looks inside himself and nowhere else. By contrast, Judge Bork has championed a key insight into our political system. Our written Constitution is law, law that is every bit as binding on the courts as it is on the Congress or on the President. And there is obviously much more to note about his contribution, and one would be tempted to go on and on. Superlatives are commonly abused in connection with Judge Bork. But one must reach for special words to honor the contribution that Robert Bork has made to constitutional theory and practice. Oliver Wendell Holmes once wrote that a great man represents a great ganglion in the nerves of society, or to vary the figure, a strategic point in the campaign of history, and part of his greatness consists in being there. Robert Bork has been and will continue to be there at a critical juncture in constitutional and political life of our nation. He has been there to inspire law students and law clerks with his dedicated teaching, and through these young men and women, his influence will be felt for years to come. He has been there to question the presumption of some courts when they have strayed into judicial activism and call them back to sound constitutional principles. And he will be there as we continue to confront the momentous constitutional and political issue of our time: who really governs in America? Let me conclude by quoting a passage about the rule of law from Robert Bolt's A Man for All Season. In this scene, Sir Thomas More's son-in-law, Roper, assails More with the charge that More would give the devil the benefit of the law. More replies, "Yes, and what would you do? Cut a great road through the law to get after the devil?" Roper, "I'd cut down every law in England to do that." More, "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper, the law being all flat? This country is planted thick with laws from coast to coast, man's laws, not God's laws, and if you cut them down, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil the benefit of law for my own safety's sake." Ladies and gentlemen, it's my privilege tonight to welcome a most able proponent of the rule of law and the great constitutionalist of our time, Robert Bork.
I have known less friendly gatherings. Ken, you've introduced me a couple of times now, and I must say you're getting better at it all the time. Also, I noticed you set a standard for sort of genetic conservatism in the family that none of us can match. Well, we're delighted to be here. My wife and I thank you very much for all of your kindnesses. And all of us who take the law seriously as something other than politics owe thanks to the Federalist Society for existing and for the courage of its members in fighting the good fight. And I think it's about time I said who we owe it to. And I would appreciate it very much if I could be allowed to recognize Lee Liberman. And I would ask her, would you mind standing up, Lee? And Steve Calabresi, who is around here someplace. Where are you, Steve? And David McIntosh. Would you stand up, please, Dave? They were 3 law students who had an idea about starting a society, and it's turned into this, and I think it's an enormous accomplishment. Now, before I begin, I want to clear up 2 misapprehensions. I spend most of my time clearing up 2, sometimes more. That is, I understand the press is here, which means that tomorrow morning this will be reported as an angry speech. There's something very odd about this. When Senator Kennedy says, "Judge Bork, you were a well-known prominent rapist," the press never says he was angry. When I say, "Senator Kennedy, that's a falsehood," the press says Judge Bork was angry. The other misapprehension I want to clear up is about who I am. People approach me all the time on the street now and say hello, and that's wonderful, except about once a week. Well, last week in Memphis, for example, an older lady approached me and said, "I want you to know, sir, we are heeding your warnings." And I said, "What warnings?" She said, "You're the Surgeon General." Well, I hope that tonight, at least before this group, I don't have to explain that I'm not Dr. Coop. And I hope I don't have to explain the fact that I recently had what you might call an interesting experience. One I recommend to you for rapid maturing and character building. And I'll talk about that for a minute. And without rehearsing the details of that experience, I think it may be called the first national political campaign with respect to a judicial nominee in our country's history. It was also, somewhat to my dismay, the first national political campaign in which only one side took part. The elements of that campaign were many, but the 2 most effective were the blitzkrieg of negative television, radio, newspaper, and mailed advertising by a massive coalition of ultra-liberal and left groups, and by what I might call Senator Kennedy's Southern strategy. The advertising preceded by falsehoods about what I had written as a professor and decided as a judge, and there are a lot of those, and I will mention only my favorite. And my favorite was Planned Parenthood's full-page ad, which characterized me, and I quote, as an ultra-conservative judicial extremist who uses obscure academic theory So much for James Madison, Thomas Jefferson, and Joseph Story. And sees the court as a reckless troublemaker, aggressively seeking ways to upset past rulings he thinks are wrong, regardless of the social havoc that may result or the pain and suffering of innocent people. Well, that's a fair description of original intent, I suppose. The ad went on, I think, in a brilliant misrepresentation of my academic writings and judicial positions, but reached its zenith by informing the public that I believe people could not choose their own relationships or living arrangements without fear of government intrusion. And it supported this with the assertion, and I quote, "Bork upheld a local zoning board's power to prevent a grandmother from living with her grandchildren because she did not belong to the nuclear family. Is this the kind of closed-minded extremist we want on the Supreme Court?" Well, when I read that, I said, that's right, this fellow doesn't belong on the Supreme Court. The case referred to, as a matter of fact, was Moore against City of East Cleveland. I was somewhat surprised to learn that I had ruled against that grandmother, since the case did not come from the D.C. Circuit, where I sat, but from the Court of Appeals of Ohio for Cuyahoga County. And it was reviewed by the Supreme Court of the United States in 1977, 5 years before I even became a judge. Not only didn't I decide the case, but to the best of my knowledge, I've never written about it or even discussed it in private. But I suppose Planned Parenthood was adopting the familiar rule of equity, which is that equity regards as done that which ought to have been done. The other aspect of the campaign was Kennedy's strategy. He spent the summer calling Southern politicians and Southern black ministers to get the issue of my nomination into black churches throughout the nation. Blacks were led to believe, entirely falsely and in direct contradiction of my record as Solicitor General and as a judge, that I was not merely opposed to the expansion of their civil rights, but was eager to take away those they had gained. The resultant uproar and the swing in the public opinion polls proved devastating to our efforts to hold the Southern senators. That's the story in briefest outline. The campaign, which went essentially unanswered, set record lows in mendacity, brutality, and intellectual vulgarity. I have not begun to convey the fury, the headlong disregard for facts or logic that was displayed. As one commentator who was not involved on either side put it, the misinterpretation has been so pervasive and its detection requires so little investigation that either the sponsors and the authors of these ads are astonishingly incompetent conceptually, or they have simply lied. Suffice it to say that if viewers, listeners, and readers believed 10% of what they saw, heard, and read, they would have been entirely correct to be terrified. If I had believed 10% of it, I would have closed the Senate Judiciary Committee hearings by committing harakiri before the cameras, which would, for many senators, have provided a satisfying climax. But I remind you of what happened, not to complain about it, or to contend that I should have been confirmed. Much of the press reports of my talks claims that that is what I am doing. I'm not. I have never claimed that there could not be or that there was not honest opposition to my confirmation. What I am doing is reminding you of the way the campaign was conducted, because the fact that there was such a campaign says much about what has already happened to our courts and what may well happen in the future. It seems highly likely that this experience will have long-term effects on the judicial nomination process of the future, effects upon the substance of our law, particularly our constitutional law, effects upon our intellectual life, effects upon our politics, and ultimately effects upon our culture. Lessons have been learned by both sides, and they will not be forgotten. My nomination became a battleground, in a long-running campaign for control of our legal culture. That campaign is in turn part of a larger war for control of our general culture. Let me start with the narrower themes. Effects upon the judicial nomination process seem fairly predictable and certainly ominous. The groups of the left succeeded in my case, and there's every reason to believe they'll be encouraged to try again. Moreover, some conservative groups who feel defeated and are bitter about the way it happened will almost certainly adopt similar tactics when a liberal is nominated. The left changed the rules, and when the rules change, they change for everybody. That would be a terrible development. What we are likely to get are political judges politically chosen. The politicizing of the nomination process will shrink the pool of men and women from which judges may be drawn, and it is precisely the most intellectually active men and women who are likely to be excluded. Even if a political nomination campaign can be won, few presidents will want to nominate men and women who will trigger such a campaign because they have expressed views that can be distorted. That obvious fact is likely to affect both the substance of the law and intellectual discourse within the law, and indeed within other subjects that bear on public policy. There are a large number of judges and professors who are potential Supreme Court nominees. There is a far larger number who imagine that they are potential Supreme Court nominees. After my experience, lower court judges must face a strong temptation to vote and to write in politically popular ways. I am sure that most of them will resist that temptation, but it should make us very uncomfortable to know that an influence so insidious is even present within the judiciary. Professors and practicing lawyers will think twice or three times before criticizing the reasoning of opinions whose results are politically popular. They will think long before publishing any controversial article. That much should seem obvious, and indeed in the case law and in the ACLU's briefs we read a lot about chilling effects, which are imagined. But indeed, I've already learned of a few examples of just that effect. Orbis, a magazine devoted to international affairs, has had two lawyers submit articles. One of them withdrew the article, and the other had its editorial contents affected. And in both cases, the authors said they did it explicitly on the grounds of my experience. The same fear of effects upon the future career has caused a law student who wrote to me to decide not to submit a piece on the Fourth Amendment and the exclusionary rule to his law review. I think, therefore, the message that went out was clear. If you have any ambitions for government service, express only noble sentiments and arrive only at non-controversial conclusions. The pressure of that message reinforces already strong anti-intellectual tendencies within the law and tends to make our courts more political. That chill on intellectual discourse is, I think, intended and deliberate. Certain ideas are to be banished from respectable discussion, are to be branded disqualifying for men and women who hold them. And the ideas thus to be outlawed are precisely those that until now have been traditional in American law. The left made much play with the claim that I was outside the mainstream. That means that those who publicly supported me, including Warren Burger, Byron White, John Paul Stevens, Edward Levy, Griffin Bell, Elliot Richardson, and Lloyd Cutler, must be seen as a cabal of extremists. It's perfectly apparent, it is entirely apparent, that what these groups are attempting is to block the traditional mainstream and divert it dramatically to the left. If by vilification you can make people believe that the center is actually the extreme right, then you can get them to think that the extreme left must be the center. That is the way the war for control of American legal culture is being fought. It would be astonishing, however, if law, which must be the most culture-bound of disciplines, did not reflect and in turn have effects upon the larger culture. Thus, we see an increasing convergence between law and politics. I don't mean simply that the politicization of more and more areas of life and institutions has now reached the judiciary and the judicial selection process. I mean something more. It seems to me, as it does to many others, that our culture is fragmenting because of this disintegration of consensus about morals and values. That disintegration inevitably affects our politics, so that Alistair McIntosh can say with much truth that modern politics is civil war carried on by other means. And as Charles Fried has said, what Clausewitz said of war is now becoming true of constitutional law. It is politics carried on by other means. If politics is war and law is politics, we can expect a constitutional law that lurches suddenly in one direction or another. We can expect a constitutional law that is seen as too important to be left to students of text and history, too important to be left to the actual Constitution. I was struck by a remark that Jim McClellan made at breakfast recently, talking about the opposition that was mounted against me and the way it behaved, or some of it behaved. And he said, these people are not liberals. He said, I don't know what they are, nihilists maybe, but they're not liberals. And that came back to mind when I read recently Hilton Kramer's piece about the liberal culture's suppression of Whittaker Chambers' great book, Witness. If you've not read that book, I urge upon you that you do so soon. Kramer spoke of the effort of some liberals to separate themselves intellectually from the totalitarian regimes of the left. And he wrote, liberalism, it turned out, was not to be so easily dislodged from the whole morass of illiberal doctrines and beliefs in which it had become so deeply embedded. And every attempt to effect such a separation raised the question of whether in what survived this process of political surgery, there was still something that could legitimately be called liberalism. I do not call what I saw liberalism. It was an unprogrammatic radicalism whose goals change, but whose one constant need is to be free of the limits set by traditional values, considerations of the legitimacy of power, or the tactics by which power is gained. These are issues that transcend the law, but law is a powerful symbol, and much about our culture will be determined depending on whether we or our opponents win the struggle for control of the legal culture. Now, we mustn't be too downhearted about a defeat here and there. I remember when I first started teaching antitrust law, I thought it was hopeless. The thing was intellectually corrupt, and the best you could do was cause pain on the way out. But I overlooked the power of ideas. Now, that's easy to do if you spend your time in faculty meetings. But ideas ultimately have much reformed antitrust law, and I do not give up the prospect that we can win this fight with ideas in constitutional law as elsewhere. I sometimes think that the issue between us is not about ideas at all, although ideas can win the issue. I sometimes think that the issue for the other side is simply power. The people I'm talking about do not seek power to implement their ideas, but hold their ideas as weapons to use in a fight for power for its own sake. It may be, that is, that there's nothing more here than a struggle for power and prestige between what has been called the knowledge class and the bourgeois remainder of society. As Richard John Newhouse puts it, the new knowledge class is composed of people who are in the ideas business. They produce and peddle the symbolic knowledge, the controlling ideas by which people live. Symbolic knowledge is the name of the game because it is by the symbols that the game is named. For reasons that are fairly well understood by now, the new knowledge class is overwhelmingly left liberal in its orientation. But it is possible to be in that class, as you all are, and still to think that you want to win because the ideas are correct, and that you want power for the sake of those ideas and not for its own sake. And I think that's what's important about this group. But if Newhouse is correct, it does much to explain the orientation, the current orientation of the universities and the law schools. It may also explain why the knowledge class would prefer to be governed by members of that class who are not disciplined by elections, that is, judges, than by those who are. Judges are freer to adopt and enforce knowledge class values than our legislators. That explains the political importance the left places upon the selection of judges who accept, or at least those who are not known to reject, the concept of unenumerated rights. Now, there are some rights that are unenumerated but are nonetheless legitimate. And I think of the original right to travel, but so perhaps a better word for what we're talking about is unindicated rights. Rights in no way indicated by the text, the history, or the structure of the Constitution. These are the rights that underlie such monuments of our jurisprudence as Dred Scott, Lochner, and Roe. They are constructed out of emanations and penumbras, substantive due process, and the Ninth Amendment. We have no idea yet as to what wonders they are capable of producing. Unindicated rights are essential for groups that cannot get their agendas enacted by legislatures. Such groups need to break the grip of constitutional text and tradition upon courts while retaining the moral authority of the Constitution. The process resembles nothing so much as the technique of deconstructionism that is being used to break the hold of other authoritative texts upon our tradition. Robert Jensen, a theologian who has seen the technique of deconstructionism applied to the Bible, said of my experience that the Senate Democrats rejected the philosophy, and I quote, that judicial interpretation of the Constitution must be just that, interpretation of something with an independent existence, in consequence of which judicial decisions will promote social desiderata when the texts do and otherwise may not. If values not enshrined in the text are to be promoted by government, this will have to be done by legislative action of the people's representatives. We are unlikely to be so wise, responded the Senate Democrats. If the oppressed are to be aided, the judges will have to do it. They are responsible not to elections, but to a mere text, which, with sufficient deconstructionist elan, can always be made to say the right things. That's Jensen's statement. That way lies not only the end of the rule of law, but the end of responsible politics. And if the public becomes fully aware of the trick we are playing upon them, that way may also lie the end of judicial review or the beginning of elected federal judges. We are the nation that created the great institution of judicial review. But it can be misunderstood, and it can be misused, and it has been. Walter Bagehot once said, The characteristic danger of great nations like the Romans and the English, which have a long history of continuous creation, is that they may at last fail from not comprehending the great institutions which they have created. As Benjamin Franklin left the convention hall in Philadelphia, he was asked what the convention had given America. And he said, "A republic, if you can keep it." Keeping a constitutional republic requires ever constant attention to its first principles. It is important, therefore, that we understand exactly what happened in our recent experience and what is the proper role of courts in a democracy. The battle about that is not over. I intend to be in it, and I know you do too. Thank you.
Judge Bork just asked, how do you stop that? And I said, the president always looks at his watch.
My watch, unfortunately.
Judge Bork is going to take a couple of questions. Now, we are running a little late, so we won't have a lot of questions. And if you could, please keep them very brief.
May I say, the fact that Ken Cribb has allowed me to take any questions shows what faith he has in this particular group. I once spoke to a group in which Mr. Cribb was present. I said, should we take questions? He said, no. And I said, why not? And he said, well, last year I was at a meeting of this group, and I was sitting at the bar, Perry, I assume, and a very well-dressed, intelligent-looking gentleman sitting next to me listened to me for a while and said, I think you're the kind of fella that thinks that John Wilkes Booth shot Lincoln. And Ken looked puzzled and said, yeah, I thought that. And the fellow said, you're out of your mind. It was a Canadian agent of the Rothschilds. And on that occasion, he would not let me take any questions. I think it's a great compliment to you that he'll let me take questions here.
I'm wondering, during the confirmation hearings last summer, the American Bar Association, the 4 members said you were, despite your distinguished record, you were unqualified to be on the Supreme Court. How would you recommend the ABA Judicial Review Committee be abolished or reformed, or what?
I'll repeat the question for purposes of the recordings. The question was, given the experience with the ABA review panel and its confirmation hearings, would he...
I say, the fact that Ken Cribb has allowed me to take any questions shows what faith he has in this particular group. I once spoke to a group in which Mr. Cribb was present. I said, should we take questions? He said, no. And I said, why not? And he said, well, last year I was at a meeting of this group, and I was sitting at the bar, Perry, I assume, and a very well-dressed, intelligent-looking gentleman sitting next to me listened to me for a while and said, I think you're the kind of fella who thinks that John Wilkes Booth shot Lincoln. And Ken looked puzzled and said, yeah, I thought that. And the fellow said, you're out of your mind. It was a Canadian agent of the Rothschilds. And on that occasion, he would not let me take any questions. I think it's a great compliment to you that he'll let me take questions here.
I'm wondering, during the confirmation hearings last summer, the American Bar Association Committee, 4 members said you were, despite your distinguished record, you were unqualified to be on the Supreme Court. How would you recommend the ABA Judicial Review Committee be abolished or reformed, or what?
I'll repeat the question for purposes of the recordings. The question was, given the experience with the ABA review panel and its confirmation hearings, would he suggest that the review process be abolished or reformed?
I don't know about abolished, how about pruned? I think, the committee got into a discussion with the Washington Post editorial writers, and it became perfectly apparent, I mean, they admitted as much, that when they said judicial temperament, they meant your view of the 14th Amendment, for example. So that it became apparent that some members of that committee regarded ideology or judicial philosophy as going to the question of temperament, although they claim that is a subject outside their jurisdiction. The ABA committee has served valuable functions upon occasion. No, they did. I remember when, I don't know why this one senator's name keeps coming up. When Senator Kennedy tried to put a family gopher, a hack, on the federal court, the ABA stopped it. And that was a valuable service.
Yes.
During your confirmation hearings, there were a number of questions about the right of privacy. Since those hearings, the press reports have revealed that that was a code word for the A word. To what extent do you think that your views on abortion influenced the confirmation hearings and the way you were dealt with?
To what extent did Judge Bork's views on abortion influence the confirmation hearings and the result?
Well, as a matter, I should say right off the bat that nobody knows my views on abortion. I have never spoken to that. I have spoken only to the constitutional question of whether abortion is a right. I don't know. One senator, Packwood, told me, and since he has talked about this in public, I think I am free to, although he didn't put it quite this way, told me that he would never vote for me unless I could assure him that I would, under no circumstances, vote to overrule Roe against Wade. He thought about that for a minute and said, of course, if you did assure me of that, I couldn't vote for you either. And at least half of that statement is principled. Senator Chafee made the same remark. If you might overrule Roe against Wade, no, can't vote for you. For the rest, I don't know. Those are the only two senators who put it explicitly. But I think it was more than that. I think it was what Professor Brewer was talking about this afternoon. I think that this question of privacy became a generalized thing. It was, if you're against a right of privacy, that means you want government in the bedroom. And it was impossible to straighten that out, even with so powerful an intellect as Joe Biden.
I realize you got the right to work about your confirmation ordeal. Do you, or I think it'd be a good idea, do you have any plans to compile all of your review articles, speeches, and whatnot? I think it'd be an excellent volume for law students and whatnot. Do you think you might do that one day so you can get it all in one book?
Does Judge Bork have plans to compile his various writings in one volume?
I think you must be an agent of the Judiciary Committee, hoping that it'll be easier to find it all the next time. No, I don't. What I plan to do after a book which I intend to write about the nomination process and what it indicates for the future. It's not a book about the ordeal. I mean, I'm not going to talk about ordeals. I'm not talking about what this experience means for the future of the law. And so after that, I intend to write a book which is only for people interested in the philosophy of this thing, not for the public, about the theory of constitutional interpretation. And I trust that will bring together the various things that I've written in one place, but it will not be a compilation.
Yes.
Judge Bork, I'm from CBN University, and recently the ABA denied us accreditation, principally on the grounds of our statement of admission, which is essentially the Apostles' Creed. In light of the question over here concerning the ABA's, I believe it was 4 votes against your confirmation, what has gone wrong with the American Bar Association and why?
The questioner adduced several pieces of evidence and then asked the ultimate question. What has gone wrong with the American Bar Association and why?
On the accreditation question, the ABA, I think, denied accreditation. I can't recall which. You're talking about taking it away from Brigham Young University and maybe Oral Roberts. And those institutions hired a law firm with which I'm familiar and won their cases. And that may be the way to go. I don't know what's wrong with the ABA. I don't know if anything is wrong with the ABA. There's some things wrong with a couple of individual members of the ABA. But I have no desire to make any general statement about the ABA. It's a very diverse set of individuals, some of whom it's possible to agree with, some of whom it's not.
Yes.
Judge Bork, when it became clear that your nomination was not secure, there began to appear press reports that you or others friendly to you had been urging the White House to take a more active role in the nomination process. To what extent is that true, and what ways might you in the future encourage the White House to take an active role without becoming a political role?
Is it true that Judge Bork urged the White House to become more active during the confirmation battle, and what recommendations does he have for future battles and White House involvement?
It is entirely true that I and a number of others urged the White House to take a more active role, which would have been not required a great deal of energy. I think it would be too bad if the White House in the future has to wage a public relations campaign in the same terms that the opponents did, because I think that's a very miserable way to discuss judges. I would hope that what a White House in the future would do, and indeed I would hope what the ABA in the future would do, indeed what I would hope the law schools in the future would do, and none of them did this, is to say, look, we take no, the White House couldn't do this, but the law schools and the ABA could have. We don't take any position on whether this man or this woman should be confirmed, but this is not the way you discuss it. You don't discuss it with these kinds of lies and slanders and misrepresentations. You discuss it on the merits. I think the White House could have done that at least. I was astounded at what appeared to be the loss of morale in establishment institutions, so that they stood there. I didn't ask for their endorsement. I never spoke to them, and I would not ask for their endorsement. But I would ask them to defend the process so that the thing was discussed in a decent and intelligent way. To my knowledge, no organized bar group did that, ever said anything about the nature of the discussion. To my knowledge, only a few law professors here and there did that. The law schools seem to have lost all interest in process. They were interested only in results. I think that's terrible. I hope the next time that the various institutions involved, whether they're for or against confirmation, will at least insist that the process be rational and the decision be made on rational grounds.
We'll do one more. Yes.
Judge Bork, I'd be interested in your comments on the critical legal studies movement and more particularly its effect on the judiciary and the future of that movement.
The question is Judge Bork's view of the critical legal studies movement and its effect on the future of the law.
I'm afraid I can't give a satisfactory answer to that. I used to say, perhaps one of the two major gurus of that movement is Duncan Kennedy. I used to say that he was a student of mine. Now I say that he was in classes I taught. I think it is an example of what I mentioned earlier, kind of nihilistic, unprogrammatic radicalism with nothing to offer the law. I trust that it will be just a rocket shooting across the legal firmament and will disappear within a few years with the 60s generation.
At this point, I'd like to recognize David McIntosh for purposes of making a presentation.
Thank you, Ken. It is my pleasure tonight, on behalf of the Federalist Society, to present Judge Bork with the James Madison Award for outstanding contribution to constitutional law. It is most fitting to honor Judge Bork with the Madison Award because, as Ken so eloquently described earlier, he has devoted his entire life to advocating principled constitutional interpretation. Whether in the role of judge, advocate, or scholar, Judge Bork has forcefully articulated simple truths, but truths that have often been forgotten or purposely ignored in the last 30 years. Those of us who knew Judge Bork were not surprised by his consistent honesty, grace, and courage in the recent hearings, where he continued to advocate these same views without timidity. But that does not make it any less extraordinary of an effort. Judge Bork has been and will continue to be an inspiration to those of us who believe in these enduring truths. It is with great pleasure and honor, Judge Bork, that we present this Madison Award, which the inscription on it is modeled after the oath and the Constitution. The Federalist Society James Madison Award for outstanding contribution toward the preservation, protection, and defense of the Constitution of the United States. Judge Robert H. Bork, March 1988.
I can't think of an award or a sentiment I would rather have, or an organization I would rather have it from. Thank you.
Well, on on that note, which we are concluding our formal program for the symposium. As you well know, well-run, complicated enterprises such as this, and I can say that because I'm a guest the way most of you are, do not happen without an immense effort. And the effort for this symposium has been managed by the local Federalist Society chapter here at the University of Virginia Law School. Alexander Whitaker, President. Nick Clesis, Symposium Director. Rob Lloyd, Program Director. Bill Condren, Registration. And he was the one who was at the bottom of the avalanche of all those cards that came. Twice as many registers here as they expected. And of course, as you know, they had to turn hundreds away from the banquet. Sally Grossclose, Richard Wilburn, who was in charge of the banquet. Jim Doherty, Doherty, excuse me, who was in charge of the wine reception yesterday, and about, come on, Jim. 70 or so UVA Federalist Society members and about 30 other UVA students. They all worked their fingers to the bone to put this on. And finally, from the national organization, Lee Lieberman and Mike Rappaport were the leads for this symposium and did a beautiful job. As all of you classical scholars know, a symposium is, in its original impetus, a drinking party. And in that spirit, I'd like to announce a change in the room number for the hospitality suite to room 231. So you can hear a pin drop. Everybody wants to get that. That concludes this symposium. We'll see you upstairs.